Good afternoon, everyone. Hopefully technology is working here. Thank you very much for taking the time to join Jordan and I this afternoon. We're certainly living in a very unique world right at the moment. And even though we're in a unique world and everyone's learning to work at home, and that fifth grade math is much more difficult than we all remember when we were in fifth grade, there's a lot of things that have been happening in the SALT world. So we thought we'd take the next hour of your day and kind of go over what's been going on for the last couple of months that is not related to COVID-19. And before I let Jordan have any words in this.
Oh my goodness, starting already.
He's ready. I also can mute him. That's something I can't do when we do this together generally in person. Couple of housekeeping things that we'll start out with, and then we're going to remind you at the end. We are giving CPE for this program. So what you need to do is we have some polling questions. You're going to have to take those polling questions, and you're going to have to complete the survey at the end. If you have any technical difficulties throughout the program, just let us know. There'll be an email at the end, or you can email Jordan and I, and we'll make sure that the CPE is handled correctly. And last but not least, the slides will be made available to you tomorrow, or email either Jordan or I, and we'll get them to you today. With that said, Jordan, your comments?
No, thank you, everybody. I'll make one correction of Maryland. It is good afternoon for those in the Central and East time zone. I believe the Mountain and Pacific, it is still morning. So let us thank you for sharing your morning with us. Says to echo Maryland, we want to get into some of the things. Not trying to diminish COVID at all, but we're trying to maintain some sense of normalcy, and Marilyn and I talking about what's going on around the country seemed like a good way to do it, both for us, which we thank you the opportunity to speak, and for you guys. And please, we have different mechanical things here. You could send us chat, send us questions, just like any other time that Marilyn and I present. We can talk a lot. Marilyn will say I talk too much, but we really want to hear from you and address your questions. And certainly if it can't be done in the context of this hour, please don't hesitate to contact us anytime, day or night. So it would be great to hear from you. We consider all of you our friends, and it's one of the things that's been hardest about this is the inability to see our friends on a regular basis.
So to kick it off, we have a polling question.
Okay.
So the first question is, what part of the country do you work in?
And we're not allowed to vote in this one, Marilyn.
No, we're not. So looks like we're pretty much done. Let's end the poll and see what the answer is. Looks like the East Coast, it looks like maybe the Midwest won, not by much, over the South. And so, because we have a pretty good mix from geographically from the group that's on the call. So,
no, the results did not come up.
All right, let's try share results. We're on a learning curve here. How about if now did they come up?
They did.
Good. So like I was saying, it was close between the South and the Midwest. But so with that being said, we've got a pretty good mix.
Yep.
So let's get started. Here is our agenda. We're going to talk a little bit about jurisdictional issues, some tax-based issues, apportionment issues, and then traps for the unwary. So we have, with that being said, let's kick it off on jurisdictional issues.
Okay, even in this time of let's make a deal, Marilyn. Let's not mention that C word, okay? Let's try to avoid it in all. You guys, so we're going to try to avoid that. But jurisdiction remains an issue no matter what. There has been some Wayfair type decisions. There's been some jurisdictional things out there, and we still think it's going to be important stuff. And that's really the topics that we picked, kind of the traditional, are you subject to tax? What's subject to tax? Where's it subject to tax? And some of the things we've run into that we would like to make you aware of that are going around the country. But this first case, I find this really interesting, Marilyn, because this is 2010 to 2012 case dealing with a net income tax, a Detroit net income tax for all intents and purposes. And it's gone up and down the judiciary in Michigan a couple of times where they found that this company did not have physical presence and therefore weren't subject to the tax. And all of a sudden, it gets up to say, well, wait a second, Wayfair occurred while this case was going on. What should we consider the ramifications of Wayfair? And I find that really interesting in that, one, it's pre-Wayfair years, so we're talking about perhaps a retroactive application of Wayfair. Uh-oh, I made her mad already. And number two, it's dealing with a net income tax. And so the question is, and so the question is, why is this the case that's kind of looking at both of those issues? So what really happened here is that a company, well, Apex is actually the successor in interest to another company, and it was whether they were subject to Detroit net income tax. And throughout the first 3 times it went to a court, the question was physical presence. And then ultimately they woke up to Wayfair. So my question is, why is this an important case?
I think this is important because I think what you're seeing, well, the court finally woke up and was told to look at Wayfair, and Wayfair, obviously, most of it was to be prospective. But I think what's important is I think it shows how local jurisdictions are struggling with the decision in Wayfair. The states have all gone out and either enacted some sort of economic presence rules, $100,000 or X number of transactions. The local jurisdictions really haven't done that yet. Some have, but if you're in the state and you meet the rules in the state, you meet them in the city. The city of Chicago has been struggling with this. The city of Chicago has not been giving people nexus rulings per se, but they've looked at whether or not they should go out and put out some sort of an economic test similar to what Illinois has put out or the other states have put out. So I think from that perspective, that's why this case is somewhat important. Now, the fact that it's been up and down several times, you'd think at some point they probably could resolve this without pushing it back up and down.
And I find it interesting, particularly in light of the MTC economic nexus standards for income taxes, the 500,000 50-50 test that's out there, that this would be important. And then two, interestingly, we've seen a shift. A couple of states who have non-sales tax, particularly, let's say, the Washington Business and Occupation Tax, used to have a $500,000 threshold. And up until this year, they imposed that 550-50. Beginning 1/1/2020, they abandoned that and adopted Wayfair, the $100,000, 200 transactions that they use for their sales tax as the threshold. So we see kind of this alignment, but that's done statutorily. This is being done without any kind of legislative impact. It's out there for a pre-Wayfair case and not a sales tax. So to me, it's kind of an oddball, but it's important. And I think your reference to the locals is really important because as you and I have been talking about, we think the locals are going to start going crazy. They're going crazy before. I think that acceleration of new taxes on businesses is only going to increase because they really need the revenue now. And it's going to be, what is the standard? And a question that's not mentioned here is Wayfair. Michigan had not adopted, Wayfair hadn't existed when these years were at issue. Michigan subsequently adopted a Wayfair thing. Now, is the Wayfair application, if Michigan's 100,000, do you need the 100,000 jurisdictional standard for each local place, or is it just once you're qualified to do business or you have jurisdiction in the state, you meet the economic presence test? Does that mean you're subject to every single local jurisdiction that passes a test?
Well, I think that's always been the issue. I mean, that issue is out there pre-Wayfair, that if you're in the state, that's been an issue with the city of Seattle on and off for years. While I know we're not mentioning that nasty C word, I think jurisdictional issues are become much more important, and you're going to see people become much more aggressive because of the need for revenue. And so they may view things, I don't know if aggressive is the right term, but they're going to take it to the bounds of where it is in Wayfair. So. And
did the litigant to this, I don't want to help Detroit here, but did they not ever hear of the Jeffrey case? I mean, Jeffrey said you don't need physical presence, you need some kind of economic presence, that's it. And all of a sudden, it's like that line of reasoning from 1993 is gone and we're jumping on the new bandwagon. It's just kind of, again, it's kind of an odd case.
I don't know if the litigants, clearly the various courts in Michigan, it's an income tax case. So I don't know why Wayfair even factored into it.
Right.
I think the other case that's on this slide is interesting, and now I believe is over because rehearing was denied, but it's Walmart.com, and what are the ground rules for collecting local tax when you are basically a marketplace facilitator? I mean, you know, and now all the laws have been put in place, but they're not in every jurisdiction. So the question is, what's your collection responsibilities? And there's a number of issues as to whose product is it, whose inventory is it, what's your presence. You're going to see more as you've got the as well. So you're going to see, these are going to be issues that are going to not go away quickly. In fact, I think they're probably going to escalate.
Right, and you know, in that case, it was definitional. It was what a dealer was for local jurisdictions, and ultimately the court held that it was not. Although there was procedural issues with respect to the, what do they call it, the efficient tax, the fast track, or whatever in Louisiana. But this is where they refused to apply retroactively a Wayfair type law, whereas kind of in Michigan, they're looking at the opposite side. Can we do it? Does it impact us? Here, ultimately, they found that they couldn't do it. They had not adopted the marketplace standards back for these years. And I think Louisiana is still struggling with marketplace type legislation and even Wayfair legislation.
I think the other thing that's important about this case is it totally turns on definitional interpretation of the statute. And I think the key that everybody needs to remember, if you don't, I mean, I think we all know it, but sometimes we forget it. Read the statute and see what it actually says, because some of these statutes are very old and they way predate Wayfair and other things. And the language in the statute does not necessarily always comport to what how it's trying to be used. And so I think there's something we do from that as well in this. Okay,
and then I'm going to flip the slide here. I mean, it continues to be an issue, and I have my own feelings on it. What's the purpose of 86-272? Just without going to all the history, because we have other things to talk about. Remember, this was put out, was it 60 years ago? 50?
1959.
1959? Okay, so that's 60 years ago. And at the time that it was passed, it was meant to address an issue that came up, Northwest States Portland Cement, when should we be subject to tax in other states for their net income tax, and was passed as a temporary measure hoping to last 6 months to a year, and now we're 60 years into it. I'll go on record. PL 86-272 still exists. The question is whether it should exist is a different question. Either expand it to include all businesses or get rid of it, because it doesn't make a lot of sense when it's based on 1960s, 1950s businesses. And I see some of the cases out there, and even what the MTC is doing, and it's like death by 1,000 cuts. They're trying to chip away of what presence is, what physical presence is, whether you have a cookie in the state, and what does it do? And now that creates physical presence. You'd listen to Mike Vitale, it's like, we're all subject to tax everywhere, 86-272 doesn't exist. I feel like, let's get rid of it then, or expand it, reinforce it, or get rid of it.
I don't know whether you got to get rid of it, but I think what the issue is, and we were going to talk a little bit about the MTC's project, what the issue is that the law is 60 years old, and the question is it doesn't fit with today's business models. And so when the MTC started this project, I think in November of 2018, it was a limited scope project. It really was, as to how you apply PL 86-272 over the last 20 years, so to speak, of how the business models have evolved. And they did issue a white paper, which I would add, if you're interested in this, I suggest you go read it, on the 23rd of March. And and it's been it's going before the Uniformity Committee, if it hasn't been there yet, with respect to the MTC as to whether this is going to come out as a policy. But the paper itself takes it hadn't been updated, I think, since the early 2000s, takes what was their draft interpretation of PL 86-272 and changes it. And it basically tries to figure out whether or not the safe harbor of solicitation, what does that cover in an internet world? And interestingly enough, there's 11 examples in the paper. And there are 2 that deal with cookies, to Jordan's point. One is the cookies that some of us on this webinar, me, understand that when you get online and you look at an item and you think, okay, I'll put that in my cart, and then you don't buy it, about 2 hours later, Brooks Brothers et al. Send you an email going, did you leave something in your cart? Those type of cookies are solicitation and are still protected. The type of cookie that is not protected the way I read this, these examples are where a cookie is put on your computer because you continually buy the same thing, or it's there because they're going to come back in and somehow assist you with some sort of, maintenance is the wrong term, but the right idea. So they differentiate between the types of cookies. But so they've added a new section to it. It's section 4, I believe, to the write-up. And there are 11 examples in there that I think are important that you ought to take a look at. What also is important in this write-up, and it probably has more impact than anything, is what this last bullet says. They've adopted a Finnegan approach to their PL 86-272. So if you look at our throwback and throw out concepts viable in a post-Wayfair world, they're really going to a Finnegan approach in PL 86-272 in their recommendation. So the question is, the last question is very important, because either with Wayfair or with this new PL 86-272 approach, the question is there ever going to be a throwback? Because you will always have some version of an economic nexus or a presence there. So
right, and interesting, they're imposing that even in the non-unitary, non-combined states, right? So it's kind of a goofy situation. But even their position with respect to non-solicitation cookies, I can't normally, let's see a show of hands. Okay, I'm putting my hand up. What business does not have some type of website which they allow people to embed cookies, which keeps track of where they are? It gives you their IP address, tells you how long they are. We all do. We all get information. And then if they're claiming that that is beyond 86-272, in essence, they are making this law unenforceable. And if they make it unenforceable, that's just a disservice, because what happens is going to be a gotcha. Some state's going to litigate it. They're going to convince the judge that the world has changed and this doesn't apply and cookies are bad and whatever else they're going to find out. And all of a sudden people are going to have retroactive liability with no warning. And that doesn't seem fair to me. So it's either we've got to, enforce this, reinforce it, say it's still the law of the land, or we got to get rid of it and tell everybody, okay, 1/1/2025 or whenever, it's gone. Something so that businesses can react and adjust, as opposed to getting whipsawed and beaten on by the states.
I think one other piece to the puzzle with adopting Finnegan and the way they're going about this is, and it really isn't a nexus issue as much as I think it has a potential impact to the composition of unitary groups and apportionment with respect to those unitary groups, which I think may be a kind of collateral damage as a result of this, because that isn't, I believe, where this whole process was supposed to go when initially.
No, with all good, all due respect to our MTC brethren, I think they got in a room and all of a sudden they started getting crazy. They came up with a single purpose that, well, as long as we're talking about that and we're going to be radical, let's talk about this. And
and there was some dissension in the ranks of the MTC too, as to how far this was supposed to go. So we do have another polling question. So let's see if I can find it. Wrong question.
No, I think we've established that.
We have
That's for recruiting.
Okay, let's try question 2.
Okay.
There are too many buttons on this. Which one of the following best represents your thoughts on Nexus?
And you guys will notice that Marilyn is in charge of the slides and the polling questions.
And you will also notice that Marilyn still has a hardwired phone that decided to ring on my.
I heard that.
Yeah.
I wish, can we ask a polling question? How many people still have landlines? That'd be I bet that will vary by a very age-based demographic.
Well, they're very important if that's what your security system is running through, and mine is. So. All right, looks like we're close. We're done. So let's share those results. Interesting. Wayfair and economic nexus standards should apply to all taxes. That's a 40%. PL 86-272 that's not surprising, should be expanded to include services. The result in that is not surprising, nor is the fact that people, the quill question.
Yeah. But I want to see who the 4 people are, don't you?
The 4 people that think states need money and should pay it. I've got some ideas about that, but yeah.
There's a judgment-free zone. So anybody, please feel free to express whatever concern, whatever your thought is at that time. It's totally okay.
Those are the people that have been home too long and homeschooling.
That's right. Let's give them some money and get the schools back up and running.
So let's talk about some tax-based issues. They are out there as well. And one of the ones that seems to be is how you treat dividends. And you'd think that this shouldn't be as big of an issue as it is. I mean, a dividend is a defined term in the Internal Revenue Code, and why you should have issues with respect to it seems beyond me, but clearly Wisconsin has created a significant amount of issues over what exactly is a dividend. And the entity in question in the Deere case was a limited partnership that was set up under Luxembourg law, but for federal purposes, federal tax purposes, and for that matter, Wisconsin purposes, is treated as a corporation. So there's 2 really statutory interpretation issues in this case. Is first, is that Luxembourg entity really a corporation for U.S. purposes? And 2, would a partnership distribution be considered a distribution of stock, or distribute a dividend that you'd get off of stock? You need to back up a bit and look at Wisconsin, which you have to have 70% ownership in Wisconsin for a DRD for foreign entities, and it has to be paid by common stock, which is sort of unique, kind of a unique requirement that doesn't exist in most states. But this also turned, when it got to Dane County, turned on statutory interpretation, and the Dane County Circuit Court walked through the statute, basically said that, look, if it's defined as a corporation for federal tax purposes, which is under the 7701 sections, then it's a corporation for Wisconsin. So we're sort of over that hurdle. And the statute refers to distributions of property. And in this case, it was cash, which is equally a distribution of property. So it's within that definition. It's a single member owner-owned entity. It can only be one type of stock, that would be common stock, and therefore you're within the confines of the statute and you should be entitled to the DRD. It's my understanding that if it hasn't been appealed, that the Department of Revenue is going to appeal this. There are a number of cases up there that have a little different twist to the cases that are up there, and we have a number of these. We probably have, what, Jordan, half a dozen of them. Yeah, that the twist is really, is the entity a corp because of the way it was formed in the foreign country. We have, I'm involved in one where one is in Poland. We have a Netherlands entity, some German entities. They would be corporations under the foreign law, but are they corporations under the U.S. law?
Right. And that's
a problem.
Right. And I see that really the issue here. One is compliance to the Internal Revenue Code, right? And whether you start with line 1 or not, or you reconstruct it, but the extent you adopt the Internal Revenue Code, what you have here in Wisconsin is they're picking and choosing certain sections, so you got to stay on top of what parts they don't accept.
Right.
And then really there's a challenge here because it is really unfair. You know, the corporation is a preferred form of doing business in our country, but in these other countries, there's other preferred forms. And, you know, I don't even know if you're allowed to be a corporation in every country. Certainly you can't. You have to have some other name, some other thing. And if you're not a corporation, then by definition, you don't have common stock. Does that preclude all those people? Is that discriminatory against interstate or international commerce? Is that a foreign commerce clause issue? And so there's a couple of different concerns. I think the court got it right. The analysis to me seems correct, saying if you're treated as a federal corp for federal or corp for federal purposes, you're a corp for Wisconsin purposes. And if you issue dividends on your ownership interest, then that would be the equivalent of common stock if it was a corp. You know, we've got some cases where it's convertible preferred, which is kind of like, you know, it's convertible to common stock, or it's not, or to different types of things. But you know, by writing this narrowly and not following the Internal Revenue Code, even though they start with line 1 is the Internal Revenue Code, section is line 26. it was line 28, and then they carve out certain things. So it's really, this is almost fit into our back end trap for the unwary. It looks like they adopt the Internal Revenue Code, and yet they pick and choose and have specific words which are not in spirit with the Internal Revenue Code.
Well, Wisconsin doesn't adopt internal, they parallel it. So they pick up pieces that they like and pick up pieces and reject those they don't. The common stock language has been in the Wisconsin statute forever, and it obviously, it goes back to a concept probably 40, 50 years ago. And so you've got to wonder if in fact that doesn't need to be changed. I mean, that is in the statute, but Wisconsin has been relatively aggressive when it comes to how they treat dividends. There's other issues in most states. You need to get to the ownership. You can use the attribution rules. For Wisconsin purposes, to get to the 70% ownership, they will not allow you to use the attribution rules, federal attribution rules, but you can use, they do allow the federal attribution rules to see if whether or not you belong in their unitary return. So they have, Wisconsin itself has some serious issues around that.
And then those cases will continue on until Wisconsin pleads out or taps out or whatever they need to do.
Well, it's on its way to the appellate court. If depending on what the court does, it's not an automatic appeal to their Supreme Court. So the next level should do it.
So we have a question here.
Okay.
Before we get off the slide, isn't E&P also relevant in the determination of a dividend?
Yes.
Well, it is, absolutely. And so thank you, Arthur, for that comment. Certainly it is. That is not for distribution, though. And I think there's a misnomer here about whether it's a dividend or whether it is a distribution of property based on a particular type of ownership, common stock here. But you're right, for purposes of dividend, it does, because it's either dividend or it's a return of capital or it's going to be gain. So it's got to be one of those three.
Yeah, but unfortunately, the statute doesn't define, the way they define dividend, it's any distribution. So it could be,
right.
Yeah.
Yeah, so it's the level of E&P is not necessarily relative to whether you qualify for the deduction in Wisconsin. It is obviously for federal tax purposes.
Well, to that end, the Wisconsin, this a little bit to do with dividends, and to Arthur's question, Wisconsin, when they come in and audit you, does not pay any attention to previously taxed income. So you get it again. So there's serious issues up there with how they're handling this, and they're
right.
probably going to become more intense given the revenue needs.
The court did a good job of doing this kind of in what I'll call the easiest way to get it done without getting into constitutional issues, foreign commerce issues. They just said, you're a corp for federal purposes. This is the equivalent of your common stock. It is a distribution. Enough said. But there certainly are challenges for this state and other states to the extent that they vary from that as to whether those disparate treatments between domestic and foreign are legitimate. And I don't know if you noticed, was it yesterday, Mike Vitale wrote about how Kraft was decided wrongly. It's a bad case like Wayfair and needs to be overruled. Well, that will have profound impact on a case like that. And if Mr. Vitale is correct, then you lose that international flavor and they can discriminate against interstate commerce or international commerce.
Mr. Vitale is not always correct at all times.
I'm right there with you.
So moving on. How dividends impact net operating losses is important, and I think it's something that we don't pay enough attention to. North Carolina has this net economic loss approach to a net operating loss. And the question with Graybar was, and they give you a DRD. So Graybar goes in and deducts its dividends from its affiliates under a 243 type, they're domestic, under a 243 type deduction. And then has income left over and carries forward its net economic losses that were earned in prior years. On audit, the department takes the position they've understated their income because effectively what they've done is they've used the DRD to increase their net operating loss. And this one also turns on statutory interpretation of what it would be, it's called that basically that it would be income that is subject to tax or not subject to tax.
Not subject to tax.
Back.
Right.
And they didn't add back the dividends in the process of determining their economic losses. So, and they go through a big analysis in this case about what would be subject to tax. And because you've got a DRD for it, even though it is subject to tax, it wasn't subject to tax in North Carolina. And so they did not get to deduct the dividends
Right.
for purposes of the NOL.
They kind of came to the conclusion that if it's not included at the base, when you have that line post apportionment and you're applying the tax rate, if it's not in that calculation, it's not taxed, and therefore they don't have to count it for their net economic loss calculation.
So I think it has some broader definition. I think it has some broader application because there's a number of items of income that conceivably may not be in that line that you could not use then to carry forward losses. I will tell you, Rhode Island has an issue as well. For those of you who may have something in Rhode Island will allow you to deduct a domestic dividend in the process of computing your net operating loss. There's a regulation directly on point. However, because, and then it says, but the only way you can only use net operating losses if in fact they're reflected on your federal return. But they also will give you a deduction for foreign dividends. But as we all know, foreign dividends are generally, never, I think, they're never deducted really on your federal return. They're not reflected there. They're generally taken with a credit. So what they've done is they've allowed you to take the DRD for domestic dividends because that'll show up on your federal return. But to the extent that you have foreign dividends, you deducted and reduced your net operating loss, you cannot use those dividends. That violates Kraft. I think they understand that. They don't like it. And there's issues with respect to it. So it's somewhat, you may see some other states that are like that. And I think as we go into the issue of what happens to guilty and repatriated income, and now with the change in some tax changes that have happened over the last couple of months, I think you need to pay attention to stuff like that.
Right. I think we're going to see, at least from the state side, the attempt to relitigate Kraft in today's environment. And this is not the first step in it, but if you look at, the combination of Wisconsin and you look at this case in North Carolina and the Deere case, I see us, if you have to expand it out, states are going to go after calculation of basic income and approach that. And certainly in the area where international transactions are going to be involved. And we're going to see Kraft at least try to be approached by the states.
Well, the combined states have pretty much said Kraft doesn't apply. So you're now pretty much down to separate return states. So let's talk about some merger issues. I think sometimes we forget, well, sometimes the salt world isn't involved when there's reorganizations in the company to the very end, or there's going to be a merger and they forget to tell you that they're involved in it. And this is a great example of what happens when you don't think through it. In this case, all America was trying to do was to merge out of existence a Michigan chartered bank, and they were merging it into a Texas entity. And there had been credits in that chartered bank, and under the terms of the Michigan statute, you could assign the credit once. The question was, when they merged it into the second entity, was that in a second assignment, and thereby they lost their credits. And the court goes through and explains that a statutory merger is not an assignment, and it's by operation of statute, this company went away. And therefore, it was not the second assignment, and it didn't violate the law with respect to utilizing the credits. I think the key to all of this is that you need to pay attention, because there's a lot of economic development credits out there. People have utilized them, and in the current environment, there may be some clawback. But as to when you start reorganizing things, which company has the credit and who's the successor in interest with respect to that credit, or you potentially are going to lose them. And then,
I could have seen the court going the other way. I mean, the credit was assigned in 2005 from one subsidiary to another. So they moved it around to someone who could use it, and then they couldn't use it. And I think it was in 2008, they formed another bank company and merged it into it. And, was that a second one? And this is one of the words where they said, it's really form over substance. I think substantively, you could certainly argue that the credit had at least two owners, and potentially the third owner. It did have a third owner. A person originally originated the credit, got assigned to a second owner, and then that second owner got merged out of existence to a third owner. If the purpose is from a bookkeeping perspective or from a viability or life of a credit, the person who earned the credit certainly wasn't involved in utilization of the credit, and all they're trying to do is limit that. But then the court kind of looked at this whole body of law and fell on the form versus substance, because substantively, you had a third owner. from a form perspective, the assignment was different than the operation of law via a merger where you have another company surviving.
It also you may want to go back and look at what the actual purpose of the credit was for. I mean, this was all being moved around within the same corporate structure, the same corporate family. But what the purpose of the credit was, I think you have other issues. I mean, if the credit was, you know, because you wanted to generate development, you're still in the same family probably doing that. So there's some thought behind.
There was not much in the way of why this reorganization took place, whether it was beyond tax purposes or anything else. And that would, to me, would have been interesting. You know, why did you do it? You know, but your initial point, Marilyn, is dead on. In corporate consolidation, reorganization, we still have to be mindful of credits, all tax attributes, net operating losses. And if nothing else, this shows that the states are still cognizant of that, and they will look to limit it whenever they can. Particularly now that they don't have the cash, the use of credits is going to hurt them.
Totally. Another fun topic, combined reporting.
Do we want to do that, the tolling question?
No, because the polling question comes after this.
Next. Oh, it's after this. I'm sorry.
Okay. All right. Let's talk about combined reporting. Just as the MTC had a committee on PL 86-272, they have had a committee working for some time on a uniformity project that dealt with combined reporting. And basically the last changes, I think, to their combined reporting write-ups were somewhere in mid-2000s, 2006, 2007. And the question is, what changes do they need to make to this to move to a Finnegan approach? And I think when they surveyed their members, they determined that most of their members were Finnegan states. And I think the Joyce states are now in the minority, although I can't say that I've really gone out and taken a poll. And so what do they need to do to change the model to get it to a Finnegan approach? And to do that, basically, they had to go to somewhat of what I would call a single entity reporting, rather than you see states where you may be a combined group, but every entity in that combined group is considered to be a separate taxpayer. So they had to go to single entity reporting. In this uniformity project, what they did was, we went through the uniformity committee in April, and they're going to hold hearings on it on June 9th, and they're accepting comments on it. But some of the things are still there. There's still a default to worldwide combined reporting with an election for Water's Edge. They did retain that. They also retain the tax haven provisions, which I think are interesting in light of the current movement of the way the feds are going with the taxation of foreign source income. So they retain the tax, but if tax havens are an issue for you, I suggest you go read their definition, because it's an interesting definition. It's not the type of definition that you see like in a Montana or in Oregon. It is an interesting definition. So I would tell you to go, if tax havens are an issue, go check out the definition that they have in this new write-up. It's also talked about, they also had issues with what was apportionable capital gains and losses and how you utilize those. Because if you're one taxpayer in a number of states, generally capital losses can only be taken by the party that incurred that loss. So they've kind of worked through that as well. But to implement this Finnegan approach, they've gone and they've defined the term person, but I will tell you that most states have defined that in their own statutes currently. So that's really not going to change so much, but it's defined as a single entity for the entire group. They have put in joint and several liability in these, and they are also put in a provision for sharing of losses, because if you're one taxpayer, then everybody gets to share in the loss. And if someone leaves the unitary group, the question is, do they take that loss with them? It addresses that as well.
And I think, Marilyn, the one thing that I found lacking in what's going on there is, just as you pointed out, kind of this consistency.
Yep.
If we're going to be treated, if we adopt combined reporting, unitary reporting, what does it mean? For some states to say that it's, well, we're entity by entity still, but then they put them all together, combine the income, apportion out based the same denominator, then they've got to accept the consequences of that. To the extent that they're going to treat them as one taxpayer, certainly Finnegan seems to make the most theoretical sense, logical sense to me. If it's one taxpayer, it's one taxpayer. Any member brings them all in. And we'll see even when we talk about later on the Washington ruling, I'm almost of a belief it's got to be done on kind of on a all tax basis. If a state's going to go unitary for income taxes, there's some ramifications in some of the other taxes that they're not recognizing. But to allow them to pick and choose the topic in which it's best for them to either throw back, throw out, combine, grab other income doesn't seem to be right. And I kind of frown upon the MTC from picking a side, but not doing it consistently.
Well, I think if you read this whole report, I think they're trying to do it consistently, but if you think consistently, but I think if you look at what the underlying theory of a unitary return is, that you're so intertwined and so interwoven that you really don't know who is generating what portion of the income, therefore you have to be combined. If that's true, then Finnegan's the right answer. I mean, if that's the theoretical basis for a combined report, then Finnegan makes much more sense than Joyce.
Right, but don't grab all my income, but in loss years say it's only the loss company that gets it. It just doesn't make any sense to me. That's
this new report, but they fixed that. That was a debate they were having. It looks to me like when I read what this redraft of everything that Helen has put together, that it looks to me like there is a sharing of losses, and that if you leave the group, you will take just like Illinois, if you leave the group, you take a portion of your loss with you.
Right, no, they've been doing it at the federal level for a long time, right? So
exactly. So I think that they've moved off of that. And I think they had a debate over how to handle capital losses and capital gains and capital losses, but capital losses particularly.
But just come with a consistent message. That's my interpretation of that.
Agree. There have been a number of states this year, although right now I think they're all pretty much on pause, that we're going to adopt or moving towards a combined reporting. Virginia had a bill out there that I think is tabled until at least next year. And I think Maryland was also looking at it. But one of the things that I think that you see that needs to be handled, and this is for somebody of me, the poli-sci major, when we talk about accounting principles, I'm the wrong one to be doing this, but clearly there's some book impacts for publicly traded companies if you move to a combined reporting regime from a separate return position. And so a number of states, when they did that, at least put some provisions in for ASC 740. And you saw it in Connecticut, I believe, had it, New Jersey had it, Massachusetts had it. We were working on it in Virginia, if in fact it went forward. So I think if you're involved in any of this, you need to recognize that you've got to take care of some publicly traded companies because the financial impact is huge. Now, Jordan, I think we have a polling question.
Woohoo!
Let me see if I can get there.
Number 3.
Number 3.
That's how many licks it takes to get to the center of a Tootsie Pop, too.
So the question is, determining the tax base has become, okay.
I like the second one.
You wrote these, so I'm sure you'd like them all. All right, we'll give it a couple more seconds here, and it looks like everybody's in. All right, let's see those results. So ridiculously hard seems to have won, but it's coming up second is not as hard as apportionment. So clearly gross receipts tax was not on anyone's mind here.
Get ready.
Well, it's an easy tax to enact, that's for sure.
Yeah, just ask Oregon. They're having such a good time of telling everybody what the heck they did. They're going to make the real permanent, real regulations now, not the other one. So
remember what our governor who went to jail and we just let out did when he tried to pass a gross receipts tax here. He forgot that the rate had to be considerably lower than what he thought. So
yeah.
Okay. Let's talk about apportionment issues, which somebody thought was easier than text-based issues here. Microsoft a little bit?
Yeah, this Microsoft case is really good because, and this is what happens when market-based sourcing first came into existence. There's obviously a lot of confusion. In the last 4 or 5 years, it's been increased. Benefit received, benefit enjoyed, benefit delivered, whatever the heck that means. this whole dichotomy then between whose benefit, and then states somewhat insisting that it would be our, not just our customers, but to the extent it is our customer's customer, or our customer's customer's customer, and somehow we to keep track of that. And since we can't keep track of it, they get to make stuff up. And how many cases do we have, Maryland, where states are just making stuff up, whether it's population or GDP or billing address? I mean, billing address is the most inane way to apportion now, because when was the last time we sent out a paper bill to anybody, right? I still write checks, I get paper bills, but in a real world, businesses don't get paper checks. They get something emailed to them. They get something digitally transferred to somewhere. There's no billing address. But it gives the states the ability, if you can't prove up where your customer's customer was, gives an ability to make something up and make it difficult for you, which generally makes a better answer for the state. This is a good case in that it looked at that, well, who is my customer? And a lot of this is going to come down to, and we see a couple of cases with this, it's going to be, who pays me? Who am I negotiating with? Who's my contract with? Not necessarily where my product ends, not ultimate delivery, but who my customer really is. And here in Microsoft, I think we've all heard of Microsoft before. They generate operating systems, and let's just make it up. Let's say they license that system to Dell, and Dell makes a bunch of computers, and then Dell sells a bunch of their computers to Best Buy, and then Best Buy sells them to you and me. Well, where do you stop the chain? Who is enjoying the benefit? Where's the market for that license? And what Wisconsin tried to do is saying, well, is ultimately the license is going to be attached to the hard drive in the computer, and when the computer gets sold to the end consumer, that's where the license or the sub-license is going to end, and therefore you should be sourcing your sales to where the ultimate customer is located. And Microsoft pushed back and said, listen, hey, look at our contracts. We have a license with the Dells of the world, the computer manufacturers of the world. That's where our license is. And beyond that, yeah, there's a sub-license, but we have nothing to do with that. And we don't contact those people. We don't deal with those people. If they got a problem, it's not our problem. And ultimately, they were able to convince the court that there was no direct relationship between the ultimate consumer, their customer's customer, or their customer's customer's customer, and Microsoft, and therefore they had to look to where their customer was. And we'll see this theme now that maybe courts are actually understanding that, one, keeping track of everything downstream from our customer is a difficult, if not impossible task. And two, it's not really what's meant by market. Our market is going to be who we deal with, not who ultimately benefits from our product.
Certainly, in this instance, Wisconsin wasn't Microsoft's market for this type of product now, but it wasn't. This case, I think, is over.
That's correct. It is over.
This quickly, we'll go through Robert Half. This is interesting to me because this has to do with what is a gross receipt for purposes of computing the sales factor. And in California, as a number of states, you can put into your sales factor, in fact, they require it, transaction taxes, be it sales tax, motor fuel tax, the like. The question is, and in California, there's a regulation of taxes that are imposed on tangible property. It is silent with respect to how you handle what I would call transaction type taxes, indirect taxes that are imposed on services. And in this case, Robert Half was collecting that on services it provided outside the US. They were successful in including the VAT tax in the denominator of their sales factor as saying that it is a transaction tax, indirect tax, and it meets the definition of gross receipts, relying very heavily on General Mills. So to me, it's maybe a planning opportunity if in fact you file a worldwide return in California and you collect a lot of VAT, you might want to put it in the denominator of your sales factor.
And remember, in California, and I think one of the lessons there is that we've had the courts in California over and over now say a gross receipt is a very broad definition. It may get limited by distortion, right? If it's distortive, we may not include it, but it gets included in gross receipt. And that's really what happened here. Yep. In the absence of a affirmation that you can include this, the court said, doesn't really matter because it's caught up in gross receipt. We really don't need that affirmation because it's still within the definition. Also,
it didn't make any sense to allow you to put it in if it was on the sale of tangible personal property, but not on the sale of a service either. Yeah. So it kind of evened it up.
No, I love this next case, this Vector case. One, they're kind of a successor in interest again, but really the question here has been going on for a long time. Let's talk about this quickly historically. I get out of the business, I sell one of my subsidiaries, I claim non-business income on my return. Then what happens? The state comes in and says, okay, that's business income. You say, okay, well, this business income, I want the proceeds in the denominator. And they say, no, that's distortive. We've been down that road a million times. This is that entire process in phase 2, part 3, whatever you want to call it. And it's something that I truly believe in, is that, and so when they sold the business, the question was, how do you apportion that? Well, you normally use the proceeds, the receipts factor of the operations of the business. I think, except in the rare exception with the changes in state law, when you sell a business, it's going to be business income if you use those assets in there. And so they initially argued that. But then what they said is, well, if it is business income, it should be apportioned on its own factors, not necessarily the operations of the business, that it would be constitutionally distortive to use my sale of widgets to apportion my gain on the sale of the business. And I think that that's something we've been arguing for a long time, and I know Maryland's had great success arguing that at the settlement level in states, is that, yes, let's stop fighting about business income and let's agree that it is business income, but maybe just putting the proceeds in the denominator is not the right way to do it, because it's just mushing up two different apportionment factors. Maybe what we have to do, and what the remand here was, maybe we need to go down and look at how the gain itself was generated and what it applies to, and it should have its own apportionment factor. Michigan, you may get a piece of it, but let's see how this income, this business income, this other type of business income was generated, and let's apportion it by those factors, not the sale of widgets. And I think it's a really good case. We'll see ultimately how this resolved, but it's something that we can go back to arguing, not that is business income, but maybe that the type of business income should be apportioned by other factors, maybe by location of assets, intangibles, tangible assets, who negotiated the deal, was it a stock sale, was it an asset sale? There's other arguments we could make to dice and slice the gain on the sale of a business, even if it's business income.
What is clear from this is they should not have kicked it out of the factor in total, because this company did very little in Michigan. It was trying to clean up an Enbridge pipeline spill. And so kicking it out of the factor wasn't the answer. And I think that's the knee-jerk reaction of most auditors, that when they see it, it's going to get kicked out of the factor, numerator and denominator. So
as distortive, or for whatever the reason.
Totally distortive. This 70% makes the distortion of this case is easy. 70%. It's when it gets a lot closer that makes it much more difficult. Correct.
And I've been looking at some cases we're arguing up in Wisconsin right now, where we have a sale of businesses that are both within and without Wisconsin, and we're breaking it. One of our arguments is that we've got hard assets in Wisconsin, we'll pay the gain on that, but the gain on the intangibles, which is on the commercial domicile, those get apportioned or cited someplace else, and we'll give you a piece, but we're not giving you all of it. Yeah, the sales of operations shouldn't dictate how you apportion this type of unique income.
I have settled, to your point, we've settled a number of cases that way. We've got about 5 minutes left. And so there's a couple, to your point earlier about benefits received. Lending Tree, there's a couple of cases that have just come down. Lending Tree out of Washington is one of those where Lending Tree would partner up individuals who are looking for loans, et cetera, with various lenders. And the question is, and then those lenders would pay a commission back to Lending Tree based on the initial, here's the introduction, then if in fact the loan was actually issued by that lender, then, or that bank, then they would get a further commission. And the question was how you source those receipts. And the question is, where was the customer? And everybody agreed that the financial institutions were Lending Tree's customers. And so do you source it to Washington, or do you source it to where the bank is located? And in this case, they looked through and they said they accrue the benefit where the service is performed, and the service is performed where that bank is located, and they did not source it to Washington State. It's a great decision, I think, with respect to how you source one of the issues in market-based sourcing.
And again, this is based upon who pays me, and that's really what it's all about. The ultimate, it's kind of a weird situation, because you and I contact Lending Tree to get sourced to a banker, but the banker then pays Lending Tree. We don't. That's just, they provide that service. It's almost gratis. So when you talk about the income that is generated by the fee paid by the bank, where's the marketplace? Where's the customer located? It's not you and I, it's going to be the banks that pay it. And that's probably a good focus, is who pays me?
And a very recent decision that came out last Friday involving Sirius XM radio out of Texas, which they've been arguing about benefits received in Texas with respect to the fees that all of us pay, the subscription fees you pay for the use of the service. It is an interesting case in that they analyze what I, as a subscriber to the service, was actually buying, and it was the ability to have the radio in my car unencrypt the signal, and therefore that's what I was purchasing. And if I'm a Texas resident, that occurs in Texas. So they source the subscription fees, look based on location of the customer, based on their address. And to the extent if there was a Texas address, those subscription fees were being sourced to Texas. The comptroller had lost all the way, had lost at the lower level of Travis County.
Right, and it was, again, and this is a Jerry Maguire, follow the money, right? Because XM and Sirius were not generating content. They were selling the right to receive.
Right.
And so the fact that content was developed outside the state, that isn't what they were charging them for. They're charging them for the right to listen to other people's content. And that's, I guess I could understand the logic of the court. I think it was a kind of a interesting decision. It's from Texas. You get blamed for all the Texas decisions, so I'm totally good with it.
Well, there's another one out of Texas that came out on Friday on the 1st that involved Lockheed Martin, and it's the circumstances around it are very limited because it has to do with government sale of F-16s to foreign governments, and what role where that sale took place, because of the way the federal law works. The federal government, because of security, obviously national security issues, is in the middle of it, and the question is who was actually the purchaser and where that tangible property was delivered. I'm trying to figure out if it has application beyond the type of transaction it was, but I think there is some interesting analysis in there that you may be able to use when you have a middleman in the middle of things, in the middle of a transaction.
And then
this one is interesting. This one is, sometimes you try to put a round peg in a square hole, and poor Railroad Friction Products Company was trying to do that. They make brakes for the railroad, various railroad cars and rapid transit cars. And they tried to argue they were a public utility because those brakes were used by a public utility, and they wanted to use the public utility's single factor apportionment formula. And the court was not having any of it. They said they were not, when they owned those brakes, they were not used for transporting goods or services or people. So
this goes under the Kathy
sometimes
Goodman.
special formulas work for you. In this case,
This is the Kathy Goodman. You don't ask, you don't get, and they did not get.
They did not get. Okay, we're on our 4th polling question here. If I can find it. I think we need to work on the polling in this program.
It's
not intuitive. Let's skip that polling question.
Oh, you may need to close.
We don't have much time left, actually. Yeah. We're over time, to be honest with you.
Well, let's just kind of go through just voluntary disclosure. I'll go through the Washington one really quick. It's about, again, this kind of what I'll call the unitary theory. Here, one member of a group was being audited. Another member of the group tried to do a VDA, and they said no because we audited one of your affiliates. Again, it's kind of the unitary style for audits and for looking at liability. And they said if we find one, we find them all. They're all subject to it. I think it's probably a bad decision, particularly for these kind of taxes where they're done on in a non-unitary state on a company by company basis. I think this is unique to Washington because we've done that in other states where you have one taxpayer who's already filing or being audited, and you do a VDA for other members of affiliate groups, and most of the states do accept them. This seems to be an exception, but it is an interesting note because it's just different than what I've experienced in the past. One
thing to take away from this is I would suggest that when you get a letter that you're going to be audited, read the language of the letter, because that's really what this turned on. It said that we are auditing X corporation and any of its subsidiaries and affiliates.
Yeah.
And they read that to say that you were put on notice. So I think I'd pay close attention to what the audit letter says. And quickly, tax analysts actually there was something in them today about trying to get the economic development programs that were put in place in Indiana to try to lure Amazon's Midwest headquarters. So they're very big on filing these type of Freedom of Information Act actions. This case where they're looking for the audit manual in Illinois, which by the way has very little in it, is on appeal. So I would, but you can see that FOIAs are important. City of Chicago had a number of issues with FOIAs, and they released a lot of information that had to do with voluntary disclosures when they changed their personal property.
As counsel, we almost always recommend we get some kind of closing agreement, so we have finality and some kind of historical record of what was done. Here is the danger of doing that. Unrelated to us, under FOIA requests or other methods by which non-related parties can get this information, states, local governments are turning over settlement agreements, resolutions, regardless of their confidentiality concerns in the document themselves. They say state law trumps it. Just be careful. I still will advocate closing agreements because I think they have more benefit than good. But here, we may have to include some kind of FOIA language that they be redacted before being disclosed, which is in the state law, but you know, that there's a copy the state gets that are redacted. If asked by a FOIA, it has to be redacted. Some other additional protections, because right now, things that you think are confidential and protected just aren't.
And we have one last poll that ties into everything that Jordan sends to some of you every Wednesday.
Hump day humor.
What is your favorite of these? Did the slide come up?
Pictures? Nope, not yet, just the poll.
Well, they like the first one.
Okay.
Well, the slide did not come up on my screen, so.
Okay, well, for those who are interested in receiving our hump day humor, it's about 10 to 12 little memes or sayings, relatively short, just dealing with what's going on in the world right now. I would say that's been fairly positive. One, send me things that you like and found are funny. I'll continue this as long as we are all sheltered in place. And hopefully it's a way of contacting and catching everybody. And our goal is every day you should have a smile. Oh, there we go. Every day you should smile. There's some good ones. The one I just got this morning, and I think one of my favorites that went out today was I'm not going to say it, pre-isolation quarantine, I want to lose 10 pounds, and now I'm only 20 pounds away from that goal. So.
It's absolutely correct. On behalf of Jordan and myself, I'll let Jordan have the same last word, which is always a disaster. I want to thank you for spending the last hour or so with us. Last word to you, Jordan.
Well, again, thank you for sharing your time during your day with us. We hope this was helpful. If nothing else, a break from either the work monotony or just being home monotony or homeschooling monotony that comes up. We're here for you. As I've said at the conclusion of all my hump day humors, we're all in this together. We all have to take steps to help each other. And hopefully this will have given you at least an hour of pleasure during the day. And notice one thing that Marilyn and I did, which we have never done. We sat down during our entire presentation, which I know it's difficult for Marilyn. It's virtually impossible for me, but for you guys, it's worth the sacrifice. Be safe, be healthy, and we hope to see you guys live soon.
Thank you.